Hey guys, this is Karalynn and welcome back to the Quit Getting Screwed podcast, where we talk about all the ways not to get screwed in the construction industry. And today we have a hot topic that everybody deals with if you're in the construction industry at some point: construction defects. And what does it look like, and how should you properly respond, and the steps you can take before you hire a lawyer. And we're going to go all over those great things today. And today with me I have a construction attorney out of Michigan, Adam Toosley. Good morning, Adam. How are you?
Good morning. How are you?
Oh, I'm great. I'm great. It's great to have you on the podcast. So before we dive into construction defects, can you tell us a little bit about yourself, how you got in construction law, all the things?
Sure. Like you said, my name is Adam Toosley. I have been practicing law for about 21 years now. Over that course of 21 years, my practice has been almost entirely real estate, which does encompass construction and construction defects. Depending on what's going on in the world, it could be more construction one day or the next, depending on, a lot of times construction stopped after the 2008 market crash, for example. There wasn't a ton of construction defect litigation. I actually grew up in a family where my mother owned a roofing company. And so I was a roofer in my summers and helped out doing that. So I had kind of a construction background just growing up, and it was always interesting to me how construction projects worked, all of the issues that would come up in that construction project world. So immediately out of law school, I went to the University of Illinois, and I started getting involved in a construction practice at a pretty large firm in Chicago, and we did everything all over the United States: construction contracts, payment disputes, defect litigation, whatever it happened to be, as it related to our primary construction clients. They were mostly on the contractor side. We did a lot of general contractor work and large subcontractor work as well. So we were usually on the defense of a construction defect claim, but it allows me now, as I do more on the other side, to really understand exactly what the contractor's thinking.
No, absolutely. And I think, if you have a background of growing up in construction, it definitely gives you a different perspective on construction law, as opposed to just coming out of law school and starting construction law, right?
Correct. It's not something that a lot of people really want to get into right away, right? You have to have a connection somewhere down the line. A lot of people aren't going to law school saying, I really want to be a construction attorney. So.
No, I agree. A lot of people just kind of end up there. You try a case or two or get involved, but it's so industry specific before it's legal specific, right? And just knowing
correct.
Scope of work and all the terminology, the first thing. And if you come in from at least a little bit of background in construction, you're way ahead of everybody else.
Correct.
So when you think construction defect, explain to me what that means to you and in your experience.
Yeah, construction defect is a really broad term, and it can mean a lot of different things, right? So it's used generically to describe anything that could go wrong on a construction project, or even after the construction is done. So you basically, from the very design phase all the way to 10 years after a project is done, you could have what we would term a construction defect. So the construction defect can be initially in the design. So if it is in the design, we usually refer to it as a design defect instead of a construction defect. But those are usually the claims to be asserted against an architect or an engineer, but can also be the contractor if, depending on the language of your particular contract, it's technically still a construction defect. But in my experience, I usually group construction defects in 5 different categories. The first one would be one where the contractor doesn't follow the drawings or the plans or specs, something like that. The second is the contractor's not following codes or ordinances when they're doing the construction. The third is if a component of the project is installed incorrectly or not in accordance with the manufacturer's specification. The fourth is a contractor not identifying components of the project correctly, so therefore the construction fails. That would be like not identifying that you can't install a component over the winter or something like that, and then the project fails. And then the fifth one, which you tend to see a lot, is especially when you have multiple subcontractors on the project, the contractor's not properly supervising the work of others, and so therefore you end up with a situation where things are not done correctly just because there's a lot of different trades working on that particular project. So they generally fall under what I would call workmanship defects versus the design defects, because there's always going to be this standard that the contractor has to meet either under the local law or under the terms of your particular contract. So that's generally what, whenever I hear the term construction defect, that's what I'm talking about, is one of those 5 non-design workmanship defects.
So real quick,
as far as how they come up is the second part of your question. I'm sorry, was the it
No,
could
go
be a
ahead.
lot of different things, right? Structural issues, right? With concrete or masonry, you'll see that a lot. HVAC and electrical plumbing are also a big area of construction defects where they've have an issue with how the wiring is done or something like that. The one that I'm seeing the most in the last 5 or 6 years are usually water intrusion, where something in the manner in which the building was built causes water to infiltrate. And then the other one is doors and windows. We get a lot of humidity, water, things like that come in through the doors and windows. And again, these are usually noticed after the fact. A lot of times they make it all the way through to finish the project. It's already been inspected. There's a certificate of occupancy. And then 6 months later or a year later, there you have a water infiltration issue or an issue with the windows and doors.
Yes, interesting. And so under your types of defects, and I think this is an important thing that kind of gets lost sometimes, is that it may work just fine, right? Whatever you install may work right now, or it may look good, but it wasn't done in accordance with the plans and specs, so therefore it's defective.
That is correct.
And so, and something
that
like
happens a lot. Yeah.
Yeah, go ahead. And something like that. So, say like they didn't follow the plans and specs, it still functionally works, right? And it's not till later on that they discover that you didn't follow the plans and specs. Like after the project's finished, been accepted, you got paid. Could they still bring up that defect at a later time?
Yes, and so that's generally referred to as a latent defect. A lot of times you'll notice that until you do something else, you could never have discovered the defect. And so a lot of times you'll see you go in to do one project where you're replacing something that just is normal routine maintenance, and then that's when you notice, wow, they put that in incorrectly or they did that wrong. So usually most states, when you're talking about asserting a construction defect claim, you can't really assert it until you know or should have known about the defect. And most people, when they're doing construction, they're not experts on construction. So it's not anticipated or expected that they would be able to, as the project is ongoing, be able to identify those defects. So the law generally allows them an opportunity to assert a claim, even if it's not discovered till years or years after the fact.
Gotcha. So so let's take this 2 ways. For a contractor who's on the project and they point out this defect or any kind of these defects while the project's ongoing, what should be either the contractor or the subcontractor's approach when a defect is pointed out? What should they do?
Well, from a contractor standpoint, assuming that there's an appropriate claim of a defect made, usually you look at your contract, because your contract will identify the mechanism for curing any sort of defaults or issues that arise. Generally, there's going to be an architect or an engineer that's assigned to that particular project who will be identified as the decision maker. And so you'd look at your internal documents, you'd go to your contract, and then you'd also go to your architect or your engineer and try to get some sort of opinion as to whether or not there's any viable basis to assert this defect claim. And then you would take all steps you can as quickly as possible to remedy that defect, because especially if it's an ongoing construction project, you don't want to do anything It's going to throw the entire project off of its course. And so if you think about it, like if you put in the plumbing and there's a defect and it takes you 3 months or 4 months to fix it, they can't actually put up the drywall or they can't do the next step. And so you end up with this snowball effect of delaying the project and then the owner making a claim against you as the contractor for not appropriately fixing the defect, thereby causing a delay in the overall project.
Gotcha. And so what would it look like if we got notice of a latent defect, like after we finish the project? What would be the first steps a contractor or subcontractor should do at that point?
When that happens, and it happens a lot, a couple of different things. One, you probably, if you're a contractor or subcontractor, do want to retain an attorney because you have to assume that this is going to blossom either into a large insurance claim or a lawsuit at some point. And you want to make sure that you've put everybody on notice that you need to put on notice, because a lot of times, depending on the nature of the defect, you may have a claim on your own insurance. And that's usually the first step, is to then tender it to your insurer so that they can take the necessary steps to investigate. Because they're going to want to hire an investigator. They're going to want to come out and check and see what the defect claim is. You may, depending on the nature of the defect, if it's small enough, just handle it internally and try to fix it. If it's a larger one, like it involves like a tear off or a roof or putting up a new wall or something like that, that's when you're going to have to go to the next step and at least put your insurance company on notice so that they can properly investigate before you do the work. Because if you then go ahead and just do the work and then make an insurance claim, they're going to say that you've not given them the opportunity to investigate whether it was a properly insured event.
Gotcha. And so let me ask you a question. I know you've been involved, and we'll get into your specific cases here in a minute, but why does everybody get sued from, like, when there's a construction defect case, they sue from the foundation guy to the roof guy to the window guy, even though it might be like a water intrusion issue on the windows. Why does everybody get sued?
Well, I can tell you that initially everybody got sued, especially because you just didn't know who did what, right? Because you're not privy to all of the individual contracts and who had what responsibility. So you just kind of say, I know all of you worked on this project. I don't know specifically if the water infiltration was caused because of the person who put the flooring in, or the person who put the floor or the walls in, or the plumber or the electrician. So I'm just going to go ahead and name all of you, and you guys sort it all out, right? You figure it out, because I don't want to waive a claim because I haven't put this one party on notice. The law has changed even significantly recently in certain states like Illinois, where they say you can only go after the party you contracted with. And this is a new change in the way Illinois law basically has stated. Originally, you could go after not only the one party you have privity of contract, the party you signed a contract with, but especially considering a lot of developers go out of business, things like that, you could then do exactly what you're talking about and go after each of the individual subcontractors. But 2 new cases came out specifically saying no. You can only sue the party you contracted with. So I'm seeing more and more of that on a nationwide basis to limit the party who's ultimately responsible.
True,
yeah, it's hard when you weren't there, right? You know, you didn't monitor it, so.
Exactly. Well, and then so even if the owner can only sue the contractor can still bring you in under indemnification if you've signed any kind of contract.
Correct. And I mean, even if you don't have an express contract, you'll probably have an implied right to be able to go after each of those subcontractors and suppliers for either defense of the claim or indemnification, saying, you know, it's your fault, or at least partially your fault, so you should be the one paying to fix this issue.
Gotcha. I do like your 5 categories here. Do you think one is more common than the other?
You know, I would say more than likely it's the failing to follow the drawings, plans, and specs that I see as the primary basis to assert most construction defects. The other ones tend to be maybe make up a quarter of it, but almost all of the time the claim I see is you were presented with this, very thick volume of drawings and plans and specs, and somewhere in there you didn't follow it, right? You didn't, and you didn't put in the right screws on this wall, and therefore it didn't work, or something like that. So usually the architect is retained by the owner as almost like a consultant, or they bring in a third-party consultant who will literally go line item by line item through those drawings, plans, and specs, and identify each of the things that they feel the contractor did wrong.
Gotcha. So, do you think there's some kind of disconnect that people don't understand what they're hired to do? What do you think it is? Why is this one? Because obviously they're given the plans and specs. Do they not? Do they think it's their bid? What do you? I'm just curious about what your opinion is.
I think it's probably a combination of a couple of different things. I mean, first off, everybody is human, right? Everybody makes mistakes. And so especially when you're talking about a larger project or a big commercial project, there's going to be a lot of moving parts. And you can't really, as far as being the contractor, watch over every single minute detail. And, people may have cut a corner. I mean, I saw it in the roofing business where you'd see people, I did a lot of flat top roofing where, like it would come up if you didn't have it at the exact right temperature. And, that's why you have warranties and you have, opportunities to cure, and you have inspections and things like that. They're supposed to pick up all of those problems. So I don't think that any contractor is obviously purposely trying not to do it. I think it's just a matter of, you could have hired a bad employee. He or she may have had a bad day that day, or, they didn't anticipate that the weather was going to be as poor as it was, and they were under a time crunch. And so they may have cut a corner, or they may have said, I understand that spec is supposed to have me do this, but I've been doing it for 40 years and it works this other way, so I'm going to do it. And take a gamble or take a risk that no one will ever catch, that they didn't follow it to a T. But it's hard. I mean, I said I've represented general contractors for a long time, and they can't be there every single day, 24 hours, or not, obviously 12 hours, whatever it is on a project, monitoring potentially 6 or 7 different trades on different portions of the project. So sometimes things do fall through the cracks.
Gotcha. So tell me about your first construction defect case and how it went, who you represented, all the fun details, or one that specifically sticks out in your mind is interesting.
Yeah, I mean, one of the things that construction defect cases are generally picked up by insurance, right? So, I don't always represent my clients in those cases, because if the insurance does agree to come in and defend them, they get to pick who it is that they want. So there has been a few times where I've had to, due to conflicts or other things like that, where I did get to represent our clients. The first one that I really remember is, it was a residential construction project where we represented a developer in that association, did the whole building, all of the buildings. And that one was specifically, they knew that the child of the homeowners had some medical issues, and it was extremely important to them that they had zero air infiltration into the property due to the fact that it could impact that child's health, which is not how construction projects work. I mean, you're not supposed to ever have zero amount of air going in and out of a property, but this one was unique and different. However, there was, in this particular instance, a lot more air than even they should have, and so they were sued, claiming that this was impacting the health and safety of the child and needed to be redone. It was a very interesting case only because it was a very volatile, and most of the time my construction defect litigation is not. It's usually, do the work, get it done, insurance steps in. This one, depositions, even all the way till we got close to trial, there was a lot of hatred back and forth, I guess is the best way to say it. And I'd say it stands out to me only because it's probably the only construction defect case that I ever did where there was that level of hatred back and forth. But we did settle the case, and I'm not supposed to talk about it because we have a confidentiality, but it ended up working out for both sides, right? I mean, and that's how almost every single one of these defect cases do eventually work out. They don't
I think you have a point that residential cases are a lot more charged because it's somebody's home, right? And especially if you're talking about somebody's child being exposed, and their job as a parent to protect them, it becomes a lot. It's almost like family law at that point, which is a whole different ballgame. But while we're on the topic of residential, I know some states have like almost a builder favor side that you have to give a notice before you can sue them. Is that do you have that in Michigan or Illinois?
We don't. I mean, both states are going to allow you to put in provisions in your particular contract as far as that is concerned. And I mean, I could talk for an hour entirely about residential construction contracts because they're really poorly drafted. But they're very contractor friendly. I even wrote an article about this last year because I tell people if you're going to do a residential project, although you may not want to do it, it's worth considering hiring an attorney for an hour's worth of time because those contracts are so friendly in favor of the contractors that I mean, like commercial ones, they're generally using a form document, right? Yeah. But residential, a lot of times they do it even without a written contract. And I just don't even understand how that happens. I mean, I've seen $150,000 residential construction projects without a written contract.
No, I agree. And especially on the residential side, the purpose in any situation of a contract is to really manage expectations. Who's going to do what? What does this look like? Like a homeowner has an expectation that this is HGTV and you're going to be done in 2 weeks. And if we don't, make that a realistic expectation, that's what you're judged against. And it doesn't come out. When it doesn't come out that way, then they're upset. So I completely agree with you with having, a mutually agreeable contract that protects both people, but number one is written in plain English, right? So everybody knows what to expect. Because then it'd be a lot less likely they'll have to hire lawyers on the back end.
And also written in larger than 8 font on the back of a page, which is the other thing I see, right? So they just kind of throw in a bunch of terms and that you need a magnifying glass to read. So.
Well, what happens most of the time is that these guys went out on their own. They borrowed the one from the guy before who borrowed it from the guy before. And it might not even be for their trade. It might even be for what they do. It might be like they're a plumber and they took a Terminator's terms and conditions. It's like most of it doesn't even apply. So it is worth taking the time, and I agree, to talk with a lawyer about how to get your contracts done right. Okay, so what happens if you don't fix a defect and you get terminated?
So the question so if you think about it from a termination standpoint, first off, you have to identify the defect while the project is still going on, right? Generally, most of these contracts do allow for that opportunity to cure before you could terminate due to a default. So if you've gotten to the point where the contractor's still working, you've taken the steps to put them on notice of the defect, they haven't cured the defect, and you've now terminated the contract, you're really kind of stuck with the idea of probably either going after them in a lawsuit or fixing it yourself and then going after them in a lawsuit for your damages, right? Those are really your two options once you've terminated them from the project. Or making a claim on their insurance, I guess, is the third one. But again, they're going to have the same sort of issues we talked about with somebody coming to inspect and then potentially hiring another contractor. And as you can imagine, insurance companies are not necessarily in the business of accepting claims either. So they usually try to find a way to get out of insurance coverage, and then you're left with hiring an attorney or filing a lawsuit or threatening to file a lawsuit and asking for a demand that they at least reimburse you for the out-of-pocket costs associated with fixing that defect.
No, I agree, and especially on the residential side and on the commercial side too. My most important mission as a construction attorney is you finish your project, right? We may or may not go after this contractor, but the resources that you have, first and foremost, finish the project. And then we can decide, yes, you have this cause of action. Is it viable? Do they have anything to collect? Do they have insurance? Are those things that we can do? But it's really hard to fight a legal battle while still trying to finish the project, in my experience. And you know, at the end of the day, you really want to try to work things out before you get terminated. And two, a lot of the things that is usually a disagreement about what something says, or, you know, and they just come to an impasse. And the problem with that is that it takes so long to figure out who is right.
Correct. And I said, and very rarely in my experience does the contractor admit right off the bat that they did something wrong, right? And so if you've terminated them due to the failure to fix a defect, you're also running the risk that maybe whoever it is that's identifying it as a defect didn't do it correctly either. So you don't want to, you said, going to what you were saying, using termination as the last-ditch effort only, because you're then potentially opening yourself up to a claim that you've improperly terminated the contract as well. So you do want to expend every single ounce of opportunities to resolve it with the contractor before you get to the point of termination or suing them, with the focus on getting it done. Even if they're going to come back to you and say, you know, we didn't think we did it wrong, but we'll pay 80% towards the fix, you're still going to be better off than suing them and, you know, being 2, 3, 4 years down the road before you recover that 80%, and then you just paid a lawyer to litigate that entire time.
And I guess that is, what does construction defect litigation look like? I mean, at the end of the day, it's really a loss for both parties, because they're going to pay attorneys more than they're ever going to get back. They have invested years of their lives in this. I mean, what do your clients say about construction litigation? Is it fun? Would they do it again?
No, for a lot of different reasons. I mean, well, first off, I mean, there's no two construction defect litigations that are alike, right? Because
I agree.
Each state is completely different on what you can and can't do. And like a construction defect litigation, I've had them in Illinois that have lasted 5 or 6 years. Michigan is usually a year to 2 for all cases at the most. So, you know, you're even looking at it differently depending on what state it is that the defect litigation potentially is going to be filed in. You have to look at your contract, because you may have attorney's fees provision in it, depending on the nature of the contract, which may, again, change how you decide or whether or not you decide to litigate. If it's litigation or arbitration is another issue that you have to decide right up front, because a lot of the commercial projects have mandatory arbitration provisions in them for construction, anything related to the construction contract. How long ago the project finished. I mean, all these things kind of go into the determinations up front as to whether or not you want to file the lawsuit. You know, again, state law is different from state to state. A lot of times you can sue for implied warranties and express warranties and breach of contract. Other states limit those warranties or allow you to limit them in your contract. So you have to, you said you're basically starting out by doing a lot of the legwork up front before you even file the lawsuit. File the lawsuit, and then you're looking at somewhere between potentially 1.5 to 6 years of discovery and depositions and motions, and then a trial and summary judgment hearings and things. So you're looking at potentially hundreds of thousands of dollars and 2 to 6 years of your life involved in litigation, when you may just want to move on, right? You may want to be saying, this project is done, you know, let's get this. I mean, very rarely do they go to trial, though. So you're probably going to get a settlement or a resolution, or you're going to win on summary judgment, or something is going to happen short of trial. I think I've probably done less than 10 construction trials in my entire career. I mean, they just, all cases settle, right? I mean, they settle on a high level percentage. But these ones in particular, especially if insurance is involved, tend to settle at some point, whether it's beginning, middle, or end. You have no idea going into it, but they do tend to resolve.
I agree, and then they should too, and the sooner the better, obviously, for everybody's sake involved. Is that, and I try to come at every situation with just being honest with the client. Like this is here's your options. This is what it'll look like, and at the end of the day, it's their decision to make. As long as I've been honest and open about here's what's going to cost, here's your time investment. This is what and sometimes you don't have a choice. Sometimes you have to do it. I understand, but I at least want you to go in with your eyes wide open. Because if not, at the end of the day, you're paying me all these attorneys. You're going to get pissed at me that I didn't tell you what was coming.
And I tend to give clients almost a written analysis with a budget up front in almost every single defect case, especially residential ones, just because I want them to understand that you may end up with a Pyrrhic victory, even if you win, in which you're basically paying an attorney to recover almost all of what you get, and then this is what your delta is as to what you would get. So I think most clients appreciate that up front, to understand, this is going to take X amount of months or X amount of years. This is your range of recovery. This is what I believe to be your percentage chance of being successful on either side, and this is how much it's going to cost to get to that. So.
Gotcha. Yeah, I agree. That's hugely helpful. Okay, is there anything I skipped over that you want to talk about as far as construction defects are involved? Did I miss anything that you think is important that people know?
I mean, I think that one of the big things is that, especially if you're the owner, and you own a piece of property and you find a construction defect at any point, is that you constantly document it, right? I mean, one of the things that I say is pictures and videos are so helpful, because people's memory on things that happened 4, 5, 6 years ago is not great. And to the extent that you can identify that I had this water infiltration issue on this date and it was investigated by this person, and then you have a picture or a video or an email. I mean, when I became a lawyer, people weren't emailing very much, but now people are documenting things, exact date, exact time, making my job as a construction attorney much easier. But everything right away. And put people on notice, put insurance companies on notice, put contractors on notice, put subcontractors on notice, and video, audio, pictures, whatever you need to do to document it, so that there isn't any question after the fact as to the steps you took when you first discovered it. That, to me, is one of the critical things, especially on behalf of the owner, that needs to be done. And I said, even before you call a lawyer, I mean, just make sure that you've documented everything that you can as it relates to that defect.
And I think it's important from the contractor side too, is that, and that's one of the first things I always tell my clients, you're calling me, even if this doesn't become an issue right now, if you don't have it already, go timeline the events of how you remember them, pull all that evidence together, and the great thing now too is, like, a lot of these contractors are using digital platforms, which saves us the time of diving through banker boxes, trying to, how much of your life was spent diving through paperwork to try to find the smoking gun email, right?
Well, I mean, it was worse because they'd be on these like weird pink paper and white, yellow papers, and we'd go through all of that.
Triplicate copies.
Yeah. I mean, the contractor side, I will say, contractors are pretty bad at saying things in emails that they don't want to say after the fact. So when you are documenting it on the contractor side, and especially, you don't want to come right out and say, why did you mess this up on the project? Or why, because that email is going to be used in the case against you, and it'll be hard to defend that you didn't cause the problem, but if you do it. So I see that a lot, where they don't really think necessarily about the next step. Like if they got like an email from the client, they then forward it to all their subcontractors and say, look at all these things you did wrong on this project. before they've even looked at it. So documenting it to a particular level is the thing to do, if that makes sense.
No, absolutely. And what I always tell my contractor clients too, if you have especially on the residential side, if you have a situation on a homeowner, usually they go out there, they're having a meeting, they come up with some kind of plan, follow that up with an email. We had this meeting, here was the plan, here was the issues, and here's the plan, right? Like, because usually they start out that way, and then they get so far apart. And so if we can get it at that point, for them and for attorneys later on, it's extremely helpful.
I mean, maybe not since COVID, but I always told people that we should immediately sit down in a room, if possible, and just work through, almost like in a punch list fashion. Like, these are the 5 things or the 10 things that we've noticed, and then we can kind of figure out the best way to attack them. But you're right, if it appears that you are cooperating, and on either side, no one goes to the extreme and says, I'm not doing anything, or I'm going to sue you tomorrow, or things like that. There should be some attempt at cooperation at the beginning, if at all possible.
No, I agree. And especially you've been in litigation for 6 months to a year, and you get to the mediation table, and nobody knew what the other side was really mad about until we got there. And that's just such a waste of time.
Right. And these things are they kind of take a life of their own too, right? Especially on the residential ones, because you'll get an email that has 200 things wrong, and it's things like this $20 light bulb's the wrong one. And so, you have to really kind of get to the point of figuring out what is the critical, quote-unquote, construction defects, as opposed to the punch list items that can easily be remedied in an afternoon or something.
Well, and I think most contractors should have it in their contract what the punch is. What is the punch list process? Because homeowners don't understand. You're going through the house, either you're building a new one, you're doing a remodel, and it's not 100% finished, and they just see you leave it and move on to something else, and they're very upset that you didn't finish this. And so if you tell them that this is, because but then again, if you take a punch list item in front of a jury and say construction defect, what are they going to say? They're going to say, oh my gosh, I can't believe you left the house that way.
Correct.
You're like, dude, it's scratch paint. I was coming back to finish, I promise.
Right.
So.
But those punch list items I've seen have been, I've seen them down to just a couple of dollars on certain items. And, just sit down and work that out. Put your differences aside and let's at least knock out all of these smaller items so that any eventual litigation is not focused on that kind of stuff. So
it's on the big stuff, yeah. So I guess we're in a consensus that the best construction litigation is one that doesn't have to happen.
100%. I think that's any construction litigation, real estate litigation, anything like this. The lawyers are the ones who end up making out in all of it, and there should be, like I said, a last ditch, only if absolutely necessary. And as you said, there's going to be situations where you have a contractor who's just refusing to do anything, and it's your only avenue of recovery, but it should never be the first attempt.
Absolutely. Well, thank you so much, Adam. I appreciate you being on the podcast, and I'm sure we'll have you on again soon to talk about another interesting, exciting topic.
Right. I appreciate it. Thank you very much.
Thanks.
Thanks.